Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, the Honorable Supreme Court of India, 3 judges bench of Justice Shri Lav Nageshwara Garu, B.R. Gawai and Madam B.V. Nagaratna. Right, they set aside a bail order given by the Patna High Court, which granted bail to the accused concerned in a murder case in which weapons were used, and held that the prosecution or the informant can bring to the notice of the higher court if the bail order lacks reasons. If the bail order doesn't have the proper reasons for granting bail, definitely either the prosecution or the informant can approach the higher court. Suppose if it is ADJ court, you can go to the High Court. If it is High Court, you can go to the Supreme Court. This is what is stated by the Supreme Court in the case of Brijmani Devi versus Pappu Kumar and another in SLP number 6335 by 2021. So this was decided on 23rd December 2021. 3 judges bench, already I told you. So if you know the facts of the case, it will be better for you to have the detailed and all in-depth study. So here what happened is the appellant, she is Brijmani Devi. She is the mother of the deceased person. So she had seen clearly the accused, that is Pappu Kumar and another, stabbing or killing her son in her house with weapons, that is Arms Act. Immediately, she went to the police station, she lodged an FIR, a case under section 302 IPC, read with 34 IPC, and section 27 of the Arms Act was registered against the accused. But the accused absconded for 7 months. Pappu absconded for 7 months. This is one story. Previously, he has got another story. Actually, he is a habitual offender on the record of the police officers. Habitual offender. Who is a habitual offender? According to the AP Police Manual, habitual offender is one such person who within a span of 5 years is convicted for more than one offence involving the breach of peace or theft or other things. Habitual offender is that one. Right. So previously, the same accused Pappu Kumar and his accomplice attacked her son, same person, the deceased, and he suffered a bullet injury at the time also. Right? An FIR was lodged in that connection also. Now 2 cases. First case 307, second case 302 IPC. But the accused absconded for 7 months. Ultimately, he surrendered to the police. He was in jail. Now he was languishing in the jail for 9 months. This is one side of the story. Then, so do you mean to say that he will keep quiet? After going to the jail, he approached the lawyers and they filed the bail petition. Of course, the trial judge, that is ADJ, he did not oblige for granting bail, ADJ court, but it was rejected. And he tried his best, or he tried his luck before the Patna High Court, suppressing his criminal activities. This is most important. Suppressing his criminal activities and thinking that this person was in jail for the past 9 months. Patna High Court granted bail, but they did not give any reasoned decision, reasoned orders. Please remember, whenever a bail is to be granted or bail is to be considered, before consideration of the bail, the court need not go in-depth study of the case. They have to look into, number 1, the nature of the crime. Number 2, the criminal antecedents of the accused. And number 3, is there any threat to the witnesses? And number 4, nature of the punishment. If it is a murder case, life sentence. If it is a 307, maybe 10 years. If it is a dowry death case, so like that, they have to think in these lines and they have to consider whether to give bail or not. No doubt, in the case of Gudikanti Narsimhalu and others versus State of AP SCC 740, 1978. So the court held clearly that while considering a bail application, the court need not enter into the in-depth analysis of the case and not required to provide lengthy reasons for granting bail. So just the 4 points which I told you earlier, if they are taken into consideration itself is sufficient. Right. Now, since the Patna High Court has given the bail, the appellant, that is Brijmani Devi, so agreed by the order of the High Court, she approached by filing an SLP in the Honorable Supreme Court of India. So our advocate stated that the accused was involved in 8 cases, out of which 3 are still pending. So accused was a habitual offender and he has been absconding for a long period of time. She argued that the granting a bail is in contravention of the law. Of course, on behalf of the accused, this is also we have to take into consideration. The advocate, on behalf of Pappu Kumar, he stated that, as usual, the accused was falsely implicated. Then second, the weapon which was used in the offence was seized from the possession of the other accused, and therefore he is nothing but brother-in-law of A1. So, and the third point is, this accused was away 350 kilometers from the place of offence. So therefore, he has to be, the Patna High Court was correct in granting bail. But Supreme Court held that while considering the bail petition, the judge, that to the level of a Patna High Court should not give the so-called cryptic orders without assigning any cogent reason. They should discuss, while granting bail, the nature of the crime, the criminal antecedents of the accused, and the punishment to be given, that is the punishment for the offence. All these things should be looked into, and then only it has to be considered whether bail has to be given or not. And so therefore, of course, it has set aside the bail order. Anyway, here the important point is, if the grant of bail, grant of bail order lacks sans reasons, definitely prosecution or the appellant or the informant can approach the higher court. This is the important point in this judgment. No doubt whether bail is set aside, whether granting is another point. Here the point is, yes, anybody can bring it to the notice of higher court if the granting order, bail order, lacks reasons. Good. Thank you very much.